Welcome to today's program titled WARN, Furloughs, and RIFs, COVID-19 series. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Condon. Condon, you may begin.
Thanks. This is Condon McLaughlin. Welcome to today's program, WARN, Furloughs, and RIFs. This is the 7th in a series of COVID-19 programs presented by Seyfarth Shaw. I'm Condon McLaughlin. I'm a partner in our Chicago office, and I chair our national reductions and restructuring practice. As we've already noted, the program today will cover reductions in force, furloughs, WARN, and benefits, issues related to each of those topics and other topics related to separations and other COVID-related events. Our presenters today include Tracy Billows, labor and employment partner in Chicago and also a co-managing partner of our Chicago office. Tracy has great expertise in absence management issues and other topics, including furloughs, which she will address today, along with Jean Wilson. Jean's a counsel in our Boston office and one of our national furlough subject matter experts. They'll be followed by Josh Deidelberg, my partner in Chicago, who is one of the nation's preeminent subject matter experts in managing and complying with the Worker Adjustment and Retraining Notification Act and state analogs, or what are sometimes called mini WARN laws. I'll be presenting on reductions in force, followed by Jennifer Kraft, an employee benefits partner in our Chicago office who has great expertise in health and welfare benefits, including severance plans, specifically ERISA plans. So with that, I will turn things over to Tracy and Jean.
Thank you, Condon. I really appreciate it. This is Tracy Billows. I'm going to kick us off with respect to our furloughs discussion. We've already seen a number of questions come in, and Jean and I frequently get this question: what is a furlough? How do you define a furlough? And certainly for some organizations, they define it very differently. But for purposes of today's webinar, when we are talking about a furlough, we're talking about an involuntary temporary period of a reduced schedule or time off from employment. We are talking, for example, about reducing a work week schedule from 5 days to 4 days. Sometimes you might hear somebody say temporary layoff or temporary leave. That's really what we're talking about. That would be a continuous period of time off for either a defined period of time, meaning 4 weeks, 2 weeks, or an indefinite period. As you see here, the primary difference between a layoff and a furlough, where employees are not working and not getting paid, is that they're often temporary in nature. What we mean by that is nobody, generally speaking, as part of a furlough, at least not with most organizations we work with, are defining that to mean actual employment and termination. Those would be reductions in force, which Condon's going to cover later in the presentation. So that's the primary difference, because at the time someone is put on a furlough, the employer's expectation is that once the business conditions improve, once those business conditions change, the individual would in fact be returning to work. Why are furloughs so much on the rise? Well, they are an alternative to reductions in force. Furloughs oftentimes work where employers and businesses are struggling with what is our current economic realities, what are our current business realities, what are our current client needs, and oftentimes organizations are not in a position to be able to make final decisions or final sort of forecasts, and so a furlough allows an organization during this period of time to work through their different financial and as well as business needs to ultimately determine how a situation will play out, and certainly to allow them time to address a temporary set of circumstances that hopefully will turn around. Salary reductions are also on the rise as part of an alternative to RIFs. Jean is going to give you some guidelines. Please note that there are very specific guidelines when reducing someone's salary, especially for wage and hour concerns, both under the Federal Fair Labor Standards Act as well as multiple different state laws on the subject as well. Why are some employers, besides some of the reasons I've already articulated, looking at alternatives to RIFs? Well, there's a few things. Number one, organizations do not want to be losing key talent when the crisis is over. Oftentimes, what organizations find is if they can keep somebody on a temporary sort of furlough situation and bring them back within a reasonable period of time, they're able to retain that key talent as opposed to a reduction in force, which is a termination and often causes people, of course, to seek employment elsewhere. Additionally, why are some people looking at salary reductions as an alternative to reductions in force? Well, salary reductions are often viewed as sort of a shared sacrifice. What do I mean by that? Everyone gets to keep working in some cases, or at least gets to keep working at a reduced schedule, still collecting a salary, as opposed to having to make that tough decision between some people having to not work at all versus some people continuing to work. So oftentimes there can certainly be, a boost in morale in terms of we're all in this together. We're all working as a team to try and get through this period of time. Additionally, depending on how an employer is categorizing their actions, whether it's a furlough, salary reduction, temporary layoff, reduction in force, there are certainly different business stimulus incentives under the CARES Act, which we're going to talk a little bit about. And there's also a different set of circumstances with respect to unemployment benefits. As I'm sure all of you are well aware, the benefits were first enhanced through the Families First Coronavirus Response Act, and then, of course, through the CARES Act. With respect to what is a furlough, one of the largest obstacles and one of the most difficult obstacles to navigate in a furlough has to do with the salary basis pay for exempt employees. As all of you know, there are various exemptions under the Fair Labor Standards Act for individuals who are in a bona fide executive, administrative, or professional capacity. And these individuals are exempt from the Act's minimum wage and overtime pay requirements. One of the key issues with respect to furloughs and exempt employees is making sure that these individuals remain in compliance with the appropriate salary threshold and the appropriate salary basis test. The reason for this is if you do not, then the individual runs the risk of being deemed a non-exempt employee and thus potentially subject to back overtime. In terms of what is the safest course if you're going to do a furlough for exempt employee, well, the safest course is to do a full week furlough. What do I mean by that? Ensure that the exempt employee is given a full work week off where the individual spends no time at all during that week, either remotely or on site, performing work of any kind. That means no emails, no texts, no phone calls, nothing at all. Because remember, under the salary basis test, if an individual performs work of any kind in a given work week, they must be paid their normal salary for that work week. So if an individual is taking calls, even though they're supposed to be on furlough, or is responding to emails, that jeopardizes the ability to be able to say that that full week furlough is in fact appropriately being deducted from the individual's pay. In terms of other considerations, with respect to the salary basis test, please remember that an individual has to maintain a minimum weekly salary as well under the salary basis test, which is currently $684. And additionally, we need to make sure with respect to your exempt employees, if you're giving them different work during this period of time, let's say you're doing a reduced sort of schedule where they're working 3 weeks out of a month because you're giving them the one full week. It is very important that if they are going to be doing job duties outside of their normally exempt job duties, that you ensure that whatever additional duties or different responsibilities you are assigning them still meet the exempt status requirements. Otherwise, again, you run the risk of violating the salary basis test and or creating a situation where they're no longer deemed as meeting the exempt obligations. What are we talking about in terms of damages? You're talking about payment for overtime for each hour worked beyond 40 in any given work week, and based on the statute of limitations, it can go back 2 or even 3 years. Moreover, that's just on the federal side. Many states have far greater statutes of limitations to be aware of as well. And with that, I'm going to turn this over to Jean to start talking about some of the other aspects of furloughs and reduced schedules. Jean?
Thanks, Tracy. I really appreciate it. As Tracy was saying, when you have exempt employees, a couple of things you're going to want to keep in mind is that you need to stay above the salary threshold for whatever the exemption is. And there's a federal amount that Tracy mentioned, and then there is also some states that have a higher level, so you want to look at that. You want to avoid any fluctuation in salary. You don't want exempt employees' salary to be going up and down. So if you do reduce the salary, you want to keep it there and really let people know that whatever salary they're being paid covers all hours for which they are working at that reduced rate. And then for other employees, you're going to want to make sure that you stay above minimum wage, that you watch any prevailing wage laws. A lot of states require advance notice of reductions in salary, so you don't want to do any retroactive salary adjustments. And that's right there as well. So you're going to just comply with those, and that's on a state-by-state basis. And then other considerations. So I'm going to talk about some other issues, and this is meant to be more of an issue spotting exercise than an in-depth analysis of these issues, but it will provide you with a good idea of the issues you want to keep in mind when planning a furlough. So the first thing we always check is, does this trigger warn? And I'm not going to address that at all because Josh is going to he's going to delve into this topic in detail, but just so that it's on your list of things to consider. The second issue is use of vacation and sick time. As Tracy mentioned, the Family First Coronavirus Response Act has come out, and that applies only to employers with under 500 employees. And it includes both a paid sick time benefit of up to 80 hours for full-time employees and 12 weeks of leave, 2 unpaid and 10 paid for certain absences that are a result of the COVID-19 pandemic. The DOL has issued FAQs related to these laws, and they make it clear that employees that are furloughed, meaning they're not working and they're not receiving any pay, are not eligible for these benefits. So whether you've already furloughed employees, they wouldn't be eligible, and if they are working and you do a furlough, that their eligibility for those benefits is going to cut off as soon as the furlough begins. The good news for folks in that situation is that while those benefits end, unemployment usually will kick in for them. If you do a partial furlough where an employee's schedule is reduced, those employees will still be eligible for benefits if they have experienced a qualifying reason for those benefits. The other thing is that states and some municipalities are now changing or adjusting their sick leave laws in response to COVID-19. So you'll want to look at the specific laws in the jurisdictions where you have employees. In addition, most employers offer sick time, vacation time, some kind of paid time off, and you're going to need to consider how you will manage these benefits for employees who are on furloughs. Some employers may want to allow employees to take the time so that employees have some income during the furlough. Other companies may be looking to cut costs and don't want to incur this expense. These issues, when it comes to sick time and vacation time, I have found in the course of the last couple of weeks are more complex than they initially seem. And a lot of issues around, can we require people to use this time? Can we prohibit them from using this time? And the answers are really different depending on what kind of time you're talking about, whether it's sick time or vacation time, and the jurisdiction where you have employees. There are some basic guidelines in terms of sick time. We do not recommend that you require employees to use sick time, particularly if it's provided pursuant to a state law or municipal ordinance. There's lots of provisions in these laws that prohibit employers from interfering or restraining use of this time, and we really advise to stay away from that. On the flip side of that, you can often broaden the reasons, except under the Families First Act. Some employers are allowing employees to use that sick time if they need to stay at home, even if that's not a reason that's covered by the sick time laws, and that is generally permissible. You can't do that under the Families First Act because then your employer wouldn't qualify for a tax credit. So if the business wants to take advantage of that, then they can only give out that time for the qualifying reasons. In terms of vacation time, allowing employees the option to decide whether they want to use that time or not is what most employees prefer, because that allows them to decide, I need the money now, I'm going to take that time, or I have enough savings, I'm going to leave my vacation time there because I want to have it when I come back. Other employers are looking at whether they can require use of vacation time. And that is likely allowable in most states except for California. California has some guidance that says you have to give 90 days notice to make that kind of change. So if you have employees in California, you'll want to pay particular attention to that if you are wanting to require use of vacation time. The other thing you'll want to do is look at your policy and make any necessary adjustments if you're going to require use, because most states require that you follow your own policy with respect to administering vacation time. Prohibiting use of vacation time is potentially more problematic, and it ties into the next issue, which is final pay obligations. There are states that require employers, when they terminate somebody, to pay them their final wages, and that may include vacation time. And we have at least two states, Massachusetts and California, that has issued guidance that a furlough could trigger an employee's obligation to pay out vacation time. So it's kind of perplexing because, as Tracy mentioned, a furlough is temporary. So why, under this piece of the law, would they treat it as a termination? And I don't really have a good answer to that, except that's the position that some states are taking, and it's something that employers need to keep in mind when they're trying to decide what they're going to do, because you don't want to create more liability for yourself on the back end. Having to pay out vacation time at the start of a furlough can really create issues for companies, especially if they're in a position where they're trying to save cash and don't want to pay this money out. It also tends to create employee relations issues because there are some employees who want to save that time and who don't want to return to work and have no accrued vacation. And as I said, in counseling employers over the last few weeks, this is one of the major issues that clients are grappling with, both from a legal perspective and an employee relations perspective. The next issue to be aware of is employee benefits. And again, I'm going to skip over this one because Jennifer is going to address that in detail. The next issue is unemployment, and this may be, if you can call it that, one of the bright spots for employees who have been furloughed. Furloughed employees, for the most part, should be eligible for unemployment benefits, and that's both if they're fully furloughed or if they are working a reduced schedule. There are partial unemployment benefits, and the eligibility for that is different in different states, but it is something you should encourage and provide your employees information about so that they know those benefits might be available to them. The federal government has also given states lots of flexibility to loosen their requirements and allow employees to collect unemployment when they're temporarily out of work because of a furlough. As some of you may know, most states have requirements that in order to collect unemployment, you actually have to be looking for a job, actively seeking employment. In the current situation, many states have changed this criteria for employees who are on furlough, and all they are asking is that you establish that you are ready and able to work and will return to work when your employer calls you back to work. Some states have now waived their waiting period so that people can get benefits immediately. And then the CARES Act that Tracy mentioned is providing for states that enter into an agreement with the federal government, and we expect that almost every state will, employees will be eligible for a flat payment of $600 per week, and that is in addition to what the employee receives in regular unemployment benefits. So it is really a boost on top of that, and it can, in fact, have people getting paid more than they would make if they were working, and that is intentional under the Act. The Act also lengthens the time of unemployment benefits by 13 weeks. Another issue we wanted to talk about is that there are some stimulus in the CARES Act. There are some employee stimulus things. One of those is the retention tax credit. And the Act provides a tax credit to employers who have closed or have suffered losses due to the pandemic. It applies to wages that are paid out from March 12th through the end of the year. It's a credit against employment taxes equal to 50% of qualified wages up to $10,000 in those wages, which essentially could be a total tax credit of up to $5,000 per employee. There's different requirements if you're a big or small employer. For employers with over 100 employees, those qualified wages are only wages paid to an employee who is not performing work. So you've actually furloughed someone, but you are continuing to pay them while they're at home. For employers with 100 or less employees, all wages are going to count. I'm not going to talk about this anymore. There's a lot of other details, and the Act is pretty complicated. So I would, and not only is it complicated, but it's very interactive. So, for instance, if an employer gets a small business interruption loan, then they can't take advantage of this retention tax credit. So you'll really want to talk to counsel and your financial folks to figure out what is the best strategy for your company in taking advantage of the options that are available under the CARES Act. Next issue is immigration issues. Just want to be aware that there are limits and additional requirements that may come into play if an employer is furloughing employees or reducing their hours. Employers with anyone
shortly.
Yep. Employers with anyone on an H-1B, H-1B1, or E-3 want to just look at that and understand your obligations. And then just quickly, you're going to want to look at any employment agreements if they have any information or might trigger any obligation. Jennifer's going to talk about severance plans, so I'll skip that, and I will turn it back over to Josh.
Good afternoon. This is Josh Deidelberg in Seyfarth's Chicago office, and I'm going to spend a few minutes going over some of the basics of the Federal Worker Adjustment and Retraining Notification Act, the WARN Act. and also state mini-WARN acts, which in some cases cover the same ground, in other cases have different requirements. So in terms of the kinds of separations that can trigger WARN, it can be a combination of terminations, that is to say permanent discharges, long-term layoffs, in the case of federal WARN, layoffs that last at least 6 months, furloughs or hours reductions. In the case of federal WARN, they have to be fairly significant hours reductions, and we'll go over that in a moment. Under California WARN, most importantly, the California courts have studiously avoided deciding whether, and if so, under what circumstances, hours reductions can constitute employment losses for purposes of applying California WARN. And then also certain types of facility closures, but also importantly, potentially closures of discrete departments, functions, product lines, or other kinds of operating units within a facility, even if the entire facility does not close. The potential penalties for WARN or state WARN violations can be significant. They typically include back pay to affected employees for up to 60 days. The value of the cost of the value of the cost of benefits that the employees would have received within that 60-day period, any out-of-pocket medical expenses that the employee or potentially the employee's family would have incurred as a result of the loss of insurance during a period for which notice should have been provided, and then also the possibility of an up to $30,000 civil fine under federal WARN and also under most of the state statutes. So in terms of WARN's triggering thresholds, first of all, truly small employers may be excluded from federal WARN, but you really have to be a truly small employer. You have to have fewer than 100 FTEs within your entire organization nationwide, including the application of a control group test. So only very, very small mom and pop type shops are excluded from potential application of the Federal WARN Act. The relative good news, though, is that WARN then drills down to look at the number of full-time employment losses at single employment sites, not company-wide. So if you are, for example, laying off 3 or 4 or 5 people at 100 different sites throughout the country, that is not going to trigger federal WARN or really any state WARNs. You do focus on individual sites. Under federal WARN, you have to do an analysis under both prongs of the test, the so-called mass layoff prong, which is essentially a headcount reduction test when you are not closing a facility or discrete functions or departments at a facility. What you look at is whether under federal WARN, at least 50 full-time employees at that site are being terminated or undertaking a at least 6-month layoff within a rolling 90-day period, and that group comprises at least 1/3 of the full-time workforce at that site. Or alternatively, you can trigger the federal WARN mass layoff test by separating at least 500 employees within a rolling 90-day period, regardless of the percentage. Then separately from the mass layoff test, you also will want to undertake a so-called plant closing analysis, where again, you would be closing either the entire facility or one or more discrete departments, functions, operating units, product lines, self-organized teams, resulting in at least 50 full-time employment losses at the site within a rolling 90-day period. So, for example, the closure of 5 10-person departments at a site could result in a covered plant closing. So will hours reductions result in a WARN event? Under federal WARN, you actually have to cut fairly deep before hours reductions will constitute a covered employment loss. You have to reduce an employee's hours at least 50% in each month of a 6-month period before that constitutes an employment loss under federal WARN. But you should recognize that if you are grappling with state WARN acts, that a number of them do not necessarily import the federal WARN concept. They're either silent on that or they have a easier to trigger threshold. Again, California is a prominent example with the California courts not indicating the extent to which hours reductions could constitute employment losses. A rule of thumb where a statute does not explicitly address hours reductions is that all or most of them import constructive discharge concepts into them. So if you are reducing hours for a significant period of time of 20, 25% or more, you begin to at least get into the red zone where you're going to have to consider if that is going to constitute an employment loss under a particular state statute. With respect to employees who are discharged for cause, and a termination for cause is an exception to the employment loss definition under federal WARN, essentially, if you are terminating for disciplinary cause, and you can establish it, because if you are challenged, you would have to show that the termination was for cause and not as an attempt to get around WARN obligations. It would be an exception to the definition of an employment loss for that employee. In terms of what information WARN notice must contain, it's important to recognize that not every communication to employees has to will comply with federal WARN notice requirements, which are set out in the Department of Labor's WARN regulations, and they can be found at 20 CFR 639.7. Essentially, you have to provide compliant notice, at least 60 days notice, to all affected non-union employees, where employees are represented by a union to their union instead of the unionized employees. There are some state WARNs in which you also, in addition to the union, have to provide notice to the individuals. You have to provide notice to the so-called dislocated workers unit of the state. You can find those addresses on the U.S. Department of Labor website. And then the chief elected official of the unit of local government to which you pay the greatest taxes, either the municipality or the county. If you're uncertain, many employers send notice to both. Federal WARN notice, or the form of federal WARN notice, can be used to comply simultaneously with most state WARN type statutes. California, New Jersey, and New York are the notable exceptions. New York has significant additional requirements. New Jersey has its own form. California, as a result of the recent executive order that some of you may be familiar with, has some modest additional content requirements. What if you don't know how long a layoff will last? And this is getting to be the existential question for a lot of employers in deciding whether they're going to provide WARN notice. So again, under federal WARN, layoffs have to last at least 6 months in order to constitute employment losses. And anytime you're doing an analysis under federal WARN, or really under the state WARNs, you are charged with acting based upon the best information available to you, and then acting in a commercially reasonable business judgment manner. You don't have to be perfect, but you can't bury your head in the sand. You have to exercise reasonable business judgment. So in a nutshell, if at the time, and this can be found in 20 CFR 639.4, if at the time that you lay employees off, you reasonably believe that the layoff is not going to last at least 6 months, you could conceivably forego providing notice at that time. If, however, the circumstances change, and only if that change in circumstances was not reasonably foreseeable as of the time of the original layoffs, when the layoffs were originated, then you could at that point provide compliant notice and presumably invoking what's known as the unforeseeable business circumstances reduction provision, which we'll talk about momentarily. However, if it was commercially reasonable for you to expect at the time that you laid employees off that those layoffs would last at least 6 months, then you would have to provide notice at that time. And then as noted, many but not all state WARN type statutes include similar provisions. Prior to the recent California executive order, California, for example, did not include an unforeseeable business circumstances notice reduction provision. It specifically and explicitly imported that concept from federal WARN for the current emergency and for the duration of the current emergency. If you need to postpone employment separations previously announced in a WARN notice, well, first of all, WARN allows you to designate either a specific date or a 14-day period during which employees will depart under that notice. And if you get to the point where you're getting close to the separation date and you realize that you have to postpone separations beyond the date that you designated in your WARN notice or beyond that 14-day period, then so long as you are postponing for less than an additional 60 days, you can give what's known as a supplemental notice, which has its own additional content requirements in 20 CFR 639.10. If, however, the postponement is for longer than 60 days, you would have to treat it as a different WARN event and potentially give an additional notice. Just to note, some of the states, the more significant and prominent states that have their own state WARN acts that have different provisions than federal WARN, typically in terms of the employment separation triggers, but in some cases they have different defenses, different notice requirements. These are probably the most prominent: California, Illinois, Iowa, New Hampshire, New Jersey, New York, and Wisconsin. For example, Illinois, New York, and Wisconsin can sometimes be triggered by as few as 25 full-time employment losses at a site. New York has a 90-day notice requirement. New Jersey will be undergoing a significant revision in their state WARN Act as of July 19th, where they will be also requiring 90 days notice and also requiring mandatory severance in many cases. Does the COVID-19 pandemic qualify for notice reduction provisions? Federal WARN and many state WARNs have two provisions that are relevant here. The most applicable is the so-called unforeseeable business circumstance provision. And what it essentially provides is that if employment losses are due to sudden, dramatic, and unforeseeable business circumstances, such as significant losses in business, then you do not have to provide at least 60 days advance notice of employment separations. You still, importantly, have to give notice. You still have to give as much notice as possible, or if it were commercially reasonable to do so, even notice after the layoffs or separations have already occurred. but you just have to provide as much notice as possible while invoking the provision and addressing additional content requirements. There's also a natural disaster provision. It hasn't been determined whether that applies to a pandemic situation. The classic examples are things like floods and earthquakes and so forth. But note that that would only apply where employment losses are directly the result of the disaster itself. And it's not clear, for example, whether if one is simply complying with CDC guidelines about social distancing and the like, and that somehow caused employment losses, whether that would be an application of the natural disaster provision. It should be noted that one of these...
Please finish promptly. Thank you.
Yes. One more moment. Just very importantly, government-mandated shutdowns are explicit examples of UBCs under federal warn. And then just a few basic considerations, other considerations. If you have a warn event based on full-time employment losses, recognize that part-time employees also are entitled to notice on the same basis. Temporary employees, in some cases, if you have project-based employees who are hired for particular projects, they may not be entitled to federal warn notice, but if they're full-time employees, they would be counted towards determining whether you have an event. Bona fide contractor employees, employees of contractors, would not be entitled to notice or counted under federal warn, but we may be dealing with broader applications of joint employer provisions under warn jurisprudence. So I'll turn it over. Just very briefly, in ambiguous situations or close situations, the statutes encourage notice, so you don't create liability for yourself by giving notice if you're not sure. And then lastly, you cannot simply apply consideration for releases or pre-existing severance provisions if they're required by contract to satisfy warn liability. You have to satisfy it through a separate payment. Condon?
As you can perhaps tell, Josh has spent the bulk of his career advising employers on warn, and he's truly a treasure trove of information. I have myself spent the bulk of my career advising employers on reductions in force. Before discussing those today, I want to provide attorneys on the call with the CLE code for today's program. That code is SS, as in Seyfarth Shaw, 8119. Again, SS 8119. These slides are in black and white. I'm not sure why, maybe because mine is the darkest of topics, but it is nonetheless necessary and likely to become more so. In following the news and legal developments over the last couple of weeks, I've come to view employer staffing actions in regard to COVID as occurring in three stages. We're in the first stage now, which is mostly furloughs. That's what we have been seeing. That's what many of you are doing. That's what some of you are still wondering about or planning for. The second stage, which may come before shelter-in-place orders are rescinded or not, will be deep cost cutting, probably across virtually all industries. Certainly, I suggest as big as we saw in 2009 in the Great Recession. We're already beginning to see an enormous uptick in unemployment claims. Some of those are for people on furlough, but it is inevitable that we will see a large economic contraction that will, I think, last for some time. And then there will be some serious actions by industries that will be seriously affected. Many companies, at least if they don't take advantage of the federal assistance that's been previously mentioned, may not bounce back. Those that do may have to do so by cutting their workforce by magnitudes never seen in our lifetime, including 08 and 09. Now, those fiscal measures, I encourage you to look at closely. The CARES Act, unlike the prior Families First bill that was mostly about paid leave and expanding FMLA, the CARES Act is about relief for employers as well as employees. And as mentioned, there is a SBA loan component available to smaller employers of less than 500. But there is an employee retention tax credit available to all employers of all sizes if your reduction or furlough, potential furlough action lasts long enough, and if you take advantage of the measures. If you keep people at full pay, for example, the government will provide you a 50% tax credit. That's a credit. They're not just going to write you a check, but they'll provide a 50% tax credit. They'll subsidize those wages up to $10,000 a quarter, I believe it is. If you reduce people's pay by half, they'll subsidize 25% of their original pay for a substantial period. So these are real measures. This is not a token gesture. This is not chump change. If you pursue this money and qualify for it, it might well make or break your company's future. What else can an employer do if it wants to do something besides furlough and avoid a reduction? Well, you can only save so many rolls of paper towels, and those you probably need these days. So one thing that I'm still seeing from clients are voluntary retirement programs. We're not seeing voluntary separation programs, and I don't expect to, not for the next 6 months. People don't have the time. Those programs, to be compliant, take at least 2 or 3 months. Voluntary retirement programs may take as long as well, but there are real savings to be had there, and those may be employees who will elect to retire early and who you can make do without at least some of them. Consider that even today. Now I'd like to talk about 5 steps beyond WARN to achieve a compliant and constructive reduction. The first of those, document the business case for RIF. We'll return to that. Second, conduct an expedited, focused, and privileged adverse impact analysis. I'll define that in a minute. Third, select employees for RIF based on specific, reasonably objective, and forward-looking factors. What do I mean by reasonably objective? Well, first of all, you're allowed to use subjective factors in evaluating managers for reductions. Courts have recognized that for years. And going forward, I think that courts will give employers a lot of latitude in subjective measures for getting by with fewer non-exempt employees, because employers are going to need workers that are flexible, that will take on new skills, that will embrace change and do more. Those are things that are hard to quantify, certainly based on past experience, but those will be key if you're going to have a workforce that's 30% less than your current. Another step, for those who must be separated, is to pay some severance to get an enforceable release. Emphasis on some, come back to that. And finally, provide impacted employees all the free and low-cost assistance you can. unemployment office information, unemployment site web links. Get them to those sites, get them to those enhanced benefits. It will help, and it may mean that they come back to you because you were the one that helped them get that sort of assistance. What do I mean by the business case for RIF? Well, it's a document. It needs to be in writing. And it's a big picture summary of the reasons for reduction, the scope of the reduction, the monetary costs, like severance, and benefits, labor cost savings. It should identify a general time frame, the planning and selection process, and the time when it's expected to be concluded. Why? Because you're going to have to defend this down the road. And you should think of this as Exhibit A. Exhibit A in support of your position statement. Exhibit A at trial. The document you send to opposing counsel in response to the demand letter. It should be focused on positions, not people. We don't target people for RIF. We focus on positions and do what makes business sense. For this to be a real, valuable document, business leaders need to buy into it. They need to review and approve it. Hopefully they will engage in drafting or at least reviewing it. But we all know HR is going to help to drive it. Without it, it won't happen. And it should be privileged while it's in draft so that it can be reviewed by either inside or outside counsel. The next thing, to avoid major class actions, whether it be race, gender, age, run a disparate impact analysis. That looks at whether you're disproportionately selecting employees in protected classes, be it particular race or ethnicity, women, older employees, the oldest of the old, those that are 60 and older versus perhaps 40 to 45. If your average employee is 43, you're probably not discriminating against 40-year-olds, even in effect. And disparate impact analysis is about the effect. And there are claims for that. You don't have to intentionally discriminate. If the numbers are really bad, you can be held liable. Who gets and should discuss the results? Well, it's going to have to be the attorneys, hopefully under attorney-client privilege, in discussion with HRs and senior management. Should not be widely disseminated, strictly on a need-to-know basis. What are the possible uses and abuses? Well, you may want to adjust some selections, not too many, or you'll undermine your overall selection system. Abuses, possible abuses, well, you can't take a African American off the list and put a white employee on in her place. That's discrimination, albeit reverse discrimination, but it would be direct, and it would be illegal, and it would subject you probably to compensatory and punitive damages. So, how do you select employees for RIF? Well, this is really much of what you may have heard before, but it's expedited just as my time is now. First of all, be aware that whatever your official process is, there, at least historically, have been unofficial processes, and you know them. A selection list is compiled. You have an objective tool to select employees for reduction. It's been vetted by legal, inside and outside. It is swell. And the results are fine. You run a disparate impact analysis. Then you get ready to notify. All of a sudden, everything's changing. All the selections are changing. There's all this horse trading. People are being torn off the list, added to the list. Happens virtually every reduction we see. Stop that. You have to stop that. You also have to minimize the number of 11th hour changes because they will not be thought through. They will be, they're not going to help. So, what should a good process look like? It should focus on roles and positions, not on people. It should contain definitions and instructions for managers. I'm talking here about an assessment tool or other systematic way to choose either across multiple incumbents, that's the most common use, but also there should be some criteria for job eliminations. What single incumbent jobs will you eliminate? If you just pick by, in effect, cherry picking, it's not going to be easy to defend. You can say, well, he adds less value, but tell that to the employee who's 55 and to a jury, and it's simply not going to be enough. The criteria you have here, but I suggest that they involve skills and competencies. They account for recent performance. If you have no consideration of recent performance, then the disconnect between the most recent performance appraisal and somebody getting selected for RIF is the most common evidence in discrimination cases. I was rated exceeds expectations just 2 months ago, and now you're telling me I'm in the less valuable cohort of my colleagues? I don't believe it. The lawyer won't believe it. An agency and a jury may not believe it. So factor for recent performance, but don't make it determinative, because what you need going forward may be something different. Somebody that can multitask, somebody who's cross-trained, somebody that could do 3 jobs interchangeably. That may be essential. Also, the process needs to be applied consistently, especially among common decision makers. Now, somebody's got to guard the guardians. That is legal and HR, who, I would say, in the first instance, we're talking legal, especially HR business partners, who often have to align with the business, support the business, perhaps against their better judgment. But if you, as an HR business partner, see something that you think isn't right, talk to the business leader that you're working with and at least make your view known respectfully, but make it known. They need your input. And legal has to provide candid advice if they see something that does not hold together or that's inconsistent with what they were told the process would be. Finally, you want a record. You want a good record. So initial selections, those spreadsheets that go flying around, those should be privileged because they're not final yet. And they can be done at the instruction of counsel, if they are in fact done at the instruction of counsel, to track demographic information and selections and service and all those things. So get those initial documents marked privileged. But when you're done, when the selections are final, then you want that to be non-privileged because you want it to be the record. Yeah, you could claim it's still privileged and maybe wave it down the road, but then you're going to have to flag it in some discovery and it's going to be suspect. So you really want to end up with a non-privileged record that reflects reality. That's why you have to stop those 11th hour changes, because they won't match what's on your record. And if they don't match what's on your record, it will be evidence of pretext. You won't get summary judgment, and Katie bar the door in terms of legal exposure. How do you minimize that? Still get a release. You want a release of all claims that can be released. From employees over 40, that means it's going to have to comply with the Older Workers Benefit Protection Act, which means you have to provide that ages and titles disclosure. No, you do not get a choice. It's the only way to get a valid age waiver. Now, maybe you want to go naked. Maybe you want to forgo that age waiver. If you don't have many employees over 40 who are affected, you have a younger workforce, maybe a technology company, don't know. But anyway, if you really don't care about age claims, okay, don't sweat the list. Carve out those claims in your release. But if you want an age release, and most reductions, for various reasons, many of them legitimate, tend to adversely impact older employees, and that's going to continue to be the case, then you want that age waiver and you must have a compliant disclosure list. The costs of noncompliance include potential exposure to class actions or collective actions, whether it's under the Age Discrimination Act or state employment laws, some of which provide for unlimited punitive damages. Potential enforcement actions by agencies. OFCCP, EEOC, even more so, haven't been active of late. But if the administration changes, if there's a Democrat in the White House come, later this year and effectively in next year, watch EEOC go to work. They'll be back in the saddle. Even baseless claims, responding to bogus demand letters costs time and money. Time might be the biggest cost because the last thing you have time to do now is to be sitting getting prepared for a deposition. I think it still makes sense to pay severance to get a release, but you may not be able to pay what you paid before. You may not be able to afford it. Does that mean you abandon it? No. Amend your plan. You can make changes to the
Hey, Condon, this is Tracy. We're at 3 o'clock, so we need to get to Jen so that people who do need to drop off can get to the benefits piece.
Thank you very much. So thank you all for attending, and I think that the other material is obviously available to you and hopefully self-explanatory. If not, let us know your questions after the call. Thank you.
Yeah, thanks, Condon. And this is Jennifer Kraft. Thanks so much. For those of you who have some more time to hold on just a few minutes, I'll be brief. Please do. If you have to drop, we are recording this webinar, and it will be available on Seyfarth's COVID-19 Resource Center in the webinars folder. But we'll go through just briefly on the benefits side. As Jean mentioned at the beginning, there's a lot of discussion in furloughs and reductions and kind of what does that mean from a benefits perspective. And a lot of it really depends on the actual status of the impacted individual. The good news there is that's largely governed by an employer's own plan, not necessarily some type of federal or state definition for benefits purposes. So if someone is terminated from employment, if we have a reduction in force like Condon was just talking about, where someone's employment is actually terminated, then we're in pretty familiar territory. COBRA rights are initiated for insured benefits like life insurance or long-term disability. There may be conversion rights in those insurance policies where an individual could convert that group policy into an individual policy for coverage post-termination. If someone is just furloughed or is on some type of leave of absence, then it becomes a little bit more complicated just because we're not used to dealing with that as much. What happens there, if there is a reduction in hours that also results in a loss of coverage under someone's medical plan, then a COBRA right is triggered. So if because I've dropped below 20 hours per week, I'm no longer eligible for medical, I've lost coverage, I can elect COBRA. COBRA information should be sent out. But this is one to look at closely. You want to look at your plan and figure out what really happens when somebody reduces hours. Do they automatically lose coverage? For some of those of you that are using the Affordable Care Act's measurement and stability periods to measure when you have full-time employees, if you've used that period, then that employee may need to continue to be eligible for medical coverage through the remainder of that stability period, even if their hours drop. If someone is receiving a paid sick leave or expanded FMLA leave under the Family's First Coronavirus Response Act, then they also need to be continued to be offered medical coverage, just like we do for FMLA today. You'd also want to check your plan's provisions related to leaves of absence. Unpaid leaves of absence, sometimes plans provide for continued coverage of benefits during that time period. Sometimes it requires employees to actually send in money to pay for those premiums. But you're going to want to check your plan and see what it currently provides. The next consideration there is to see is that what it currently provides what you want it to provide. And you may decide you want to amend the plan to provide for some type of continued coverage while people are on this unpaid leave of absence or on a furloughed status. If you do, and you're fully insured, you're going to need to work with your insurance carriers to make that change. If you're self-insured, you have a little bit more flexibility. But even with a self-insured medical plan, you'd want to coordinate that type of amendment or change with your stop-loss insurance carrier to make sure that they would continue to cover any of that expanded group. You may also think about, if you want to desire to bridge those benefits, if you want employees to make some type of contribution. If employees are terminated, do you want to provide some type of COBRA subsidy? There's a lot of flexibility there, but your plans would need to be reviewed and possibly amended. On the flexible spending account, just a quick plug in here, we've received a lot of questions, particularly related to dependent care flexible spending accounts and changes participants are requesting to make because daycare centers are closed or they've reduced hours and they don't need daycare as much. The IRS rules do permit mid-year changes in elections for dependent care flexible spending accounts in many of those situations. The last piece I'll just hit on it, following up what Condon was saying about severance plans. If you are going to a reduction in force route, we highly recommend looking at your severance plan, if you have one in place, making sure it's got the right group and benefits. You may need to amend that. If you don't have a severance plan in place, we recommend considering an ERISA severance plan. Again, you can design it. There's a lot of flexibility in your group and benefits, and to Condon's point, getting a relief is critical. You can offset some of the WARN notice provisions if they are applicable that Josh was talking about. And having your ERISA plan your severance plan be subject to ERISA provides a number of advantages, including a mandatory internal claims and appeals process before any dispute would go to court, which can help resolve disputes in a more cost-effective manner. If a matter does go to court, there's a deferential standard of review, typically, of those decisions. Any decision would be in federal court, but decided by a judge, not a jury. And it would preempt state law claims such as misrepresentation, fraud, or breach of contract, which could also include punitive damages. So we highly recommend those. We are 6 minutes past the top of the hour, so we thank you all very much for joining us today. If you have more questions about the employee benefits issues in general, we did an employee benefits COVID-19 webinar last Monday, recording of which is also available on Seyfarth's COVID-19 Resource Center in the webinar section. And so I'll close with that on the benefits piece.
Thank you, Jen. And as Jen mentioned, that we are out of time. I did notice that we've answered a lot of the questions that all of you raised during the course of the presentation. I also know that we're going to be sending out a recap of the webinar where we will try to get to many of these other questions that we just could not get to today. We thank you all for your time. And again, make sure you're reaching out to your resources on these issues. Seyfarth has some great resources and, as you can tell, some great thought leaders in all of these areas. Thank you for your time this afternoon.
This concludes today's webinar. Thank you for attending.